Somebody who designed you, for example, God making all of us, gave us unique features, makes our designs unique. And that is why we have products in society like the air conditions, the cars, the aeroplanes, the televisions, and the fridges, and everything in our homes have got an outside appearance which is registered under patent, under designs. And so under industrial property, design is one of the parts which also we can seek protection over it. If you have any idea of how to design a mobile phone with a specific unique feature, that outside appearance, you are protected. That is why you cannot get up to create a car and pick up the design of another company and make it your own. And so we should always be mindful about that. It also borders in music. It doesn't come in music precisely as the music notation or the rhythm or the harmony. But then the event you host and the designs you do, if somebody also picks those kind of designs as per your own creativity for your music event, you can still fight over it if you have registered the event designs within it. And then we have trademark. Trademark comes in 3 different forms. We have a name which becomes a trade name. For example, Bnoskka. The name Bnoskka is my trade name. And so therefore I use it to trade. I use it to do programs. I use it to do events. And then I've designed it as a logo as well. And that logo also becomes a mark. And so if I create a TV and call it Bnoskka TV, or if I create a television and I call it Bnoskka Television, then that logo on that television will be a trademark where people will see it and believe that, yes, indeed, it's a trademark which is coming from Bnoskka. And so therefore, if anybody also makes another simple object or any other thing, be it a cloth or any product, and you put the name Bnoskka on it, you would also be fined infringing on that trademark. For example, Adom TV, their microphone here and their label on it is a design and which is form part of intellectual property. Then we also do have what we call name, which I've already said, name. And then we have images, which can be either a logo or any symbol which can identify. For example, Apprise music symbol, which is my partner in this public lecture. The symbol behind us also is a trademark. And so the logo within it, you cannot pick it and use it for any other thing without authorization from the company. And so if I don't have the authorization, they wouldn't be able to display their logos here because I would be infringing on their rights by using their trademark to sell my product. In other words, telling people that, oh, Bnoskka's production is very good. That is why Apprise music logo can be found in it. Or Adom TV can be found in it. Or Onia TV can be found. And even as we're talking, Asempa FM also picking it live, their logo being here also signifies that they also are agreeing and I am not infringing on their right because it's an agreement which we've had. And so that is intellectual property under the industrial property. Then we come to copyright, where copyright also here looks at the expressive qualities of any image or anything we create, be it a film, be it music, be it clothes that we are wearing, fashion designers, even computer games, animations, textiles and fashion, leather work, even folkloric materials, all fall under copyright. And that is why copyright, therefore, here protects the artistic creativity of people who use their brains to create songs or film or anything which is of artistic expression. So if you do a leather work, you make a shoe. The shoe, outside appearance of the shoe, which is the design, is under design. Then a name which you put on the shoe becomes a trademark. And then how you have been able to make the shoe as one complete, you can patent it. And then if you make a song about your shoe, it falls under copyright. And that is how I want us to understand. And so therefore, let's look at how does copyright protect music. Copyright gives us protection in music in 3 different forms. We have what we call the creation of the music, which is create. If you want to create a music and you want to make sure that you are protected, you have to make sure that your songs that you are creating is your original work. And original here means that you want to create in the genre of Ghanaian high life, either palm wine or osode or adowa or any of the Ghanaian traditional music that we know in Ghana. That creativity that you are going to create can be in a form of words, can be in a form of melody, vocal melody, or can be in a form of musical notation, either by staff notation or tonic notation. And this kind of notation, you are also protected under law. And how does the creation becomes original? It becomes original when everything in it, the melody, the lyrics, the text, the harmonies involved, are your own creativity from your head that you have created. And I must say that intellectual property is a property just like our house, our car, our fridges, everything that we have that we hold it dear, including land. So that intellectual property, because we cannot hold it, and so therefore people think that somebody else should protect it for you. No, it is your own personal right. So if you have the imagination, if you have the knowledge to create it, then you are the rightful owner to be able to protect that work. We will come under the protection. But let's look at the creation. Now, people think that I want to create a work. And that creation, that work I'm going to create, I think I want to create it to look like something. Somebody has created a song and I like it. Then you go and pick a part of it. That is what we call sampling. And sampling comes into 3 different forms. You can sample by copying the work directly and then placing it in your original work. It is against the law. Or you can pick what we call interpolation. Interpolation here in music means that the person plays the bass guitar and you pick the bass guitar pattern he played and put it into organ or put it into voice or even arrange it for a different musical instrument within your work. And when that person hears it, for example, the Yaponsa sound that we all know, that you can pick the Yaponsa sound and then put it into an organ. Organ will play it. If it is against the person's wish and he sues you in court, you will be found wanting because you have interpolated his work, which is interpolation. Then you can also do what we call copying sample. Copying sample here means that you have picked the work word for word or melody for melody or rhythm for rhythm or beat for beat and then drop into your work completely without any changes. Copying, sampling. And when you do, you might be thinking that, oh, I like Kwame Eugene, I like Shatawale, I like Stoneboy, I like Fameye, I like Kofi Kinata. And so what I'm doing, I am promoting them by copying their work into my own work. It is unfortunately not so. Nobody wants you to promote anybody. If you want to create your original works, make sure you are not copying anybody, either by interpolation, either by simply copying. The next part of the sampling, which people also think that it's not against the law, is what we call rework copying or rework sampling. Rework sampling here means that you have picked a particular song and then the person did the song in reggae and you change the work completely and turn it into a high life. And we all know that reggae beat is different from high life beat. And so you have reworked the whole work, but you have sampled. You are not allowed by law to do that. Because the moment you want to pick somebody's work, you need permission from them. And so that is the part of creation. You cannot create your work and be using other people's material when you do not have right over them. Now let's look at how do you protect your work. The law gives us 3 forms of protection. The law wants to protect you so that when you have created your work, people will respect your work and be able to make sure that they also help you to get food or to get economic benefit. And so these 3 forms of protection, the first one is what we call moral right. Moral right here means that your name must be called on your work anytime, anywhere in the world. Anytime somebody calls the song or the work and they mention another person's name, you can sue the person in court. And even if you die 1,000 years and your children or your great-grandchildren are there and somebody sings that particular song and they attribute it to another person's name, your great-grandchildren can go to court and that person will be found wanted. And so we should understand that moral right does not expire. It exists in law. We call it perpetuity, meaning forever and ever, until the whole world ends and we all here are no more. Forever and ever, intellectual property, the moral right of your name being associated. Now let's look at what are some of the benefits or characteristics on moral right. Moral right gives you the permission or the authority to be able to prevent people from using your work in a way that will tarnish your name or your image. For example, I've made my song, and then you come and tell me, Bnoskka, I want to use your song for a beer advert, and I don't like beer. And I didn't give you my permission, and you go ahead to use it. I cannot sue you for infringement. I will sue you for my moral right's sake, because you are tarnishing my image. I am maybe a bishop or maybe a Muslim, and I don't drink alcohol. So why are you using my song in my name to promote your product? Even if it has fallen free, I have no economic right over it. Once my name's sake, you want to tarnish my image, I can go to court, or even my great-grandchildren can go to court and say that our father never liked beer, or he never liked pito, or he never liked alcohol, or he never liked any advert about football, or anything about lottery or betting. And so please don't use his works in that because of his namesake.